Welcome back to this final part of Leasehold Covenants. In this law session segment, we will look at, we will continue to look at how the relationship between the landlord, the tenant, and the assignee, or the landlord, the tenant, and a subsequent purchase of the reversioner all work in tandem. What we will of course start with is let's consider for a moment that there is a head lease, and as it relates to the tenant, there is privity of contract there, and there's also of course privity of estate, so the original L&T relationship. As there is privity of contract and privity of estate between L and T, L can enforce any covenant between and against T. If either L or T sell or assign their interest, the principles stated will certainly continue to apply. Now, as there's privity of contract and privity of estate between, let's say, the tenant and the sublessee. Now, I ended on the last segment saying we would go into considering sublessee, so I don't want you to feel that we have gone off track. What I want you to consider for a moment is, if you consider the landlord, below that vertical line, the tenant, below that vertical line, the sublessee, there is privity of contract and privity of estate between the landlord and the tenant. But what about the relationship between the tenant and the sublessee? Well, there is no privity of estate or contract between L and S, the sublessee, but there is, of course, privity of contract between T and S. So T can enforce any covenant as against S. If either the tenant or the sublessee sell or assign their interest, then again, the principles will continue to apply. But the thing to take on board is that there is no privity of contract or estate between landlord and sublessee. So the landlord cannot enforce any covenants against the sublessee, and the sublessee cannot enforce any covenant against the landlord. So for example, the landlord rents to me, I rent to S, so imagine I'm T. If it is that, for example, I move off to the USA, for example, and the roof needs fixing, it is not the sublessee's business to then say that he is going to bring an action against the landlord. But if the sublessee breaches a covenant, the tenant will still be liable to the landlord under the head lease if the covenant is contained in the head lease, and therefore it would then affect the sublease. So if we consider for a moment the relationship between the various parties, again, let's look at landlord to tenant, tenant to A1, tenant to A2. Well, the burden of the tenant's covenants, that is where the landlord or a purchaser has the benefit, will pass to the assignee if they touch and concern the land, and there is privity of estate. Privity of estate, as I said, exists where the parties stand in the same position. The benefit of the tenant's covenants equally will pass to the assignee. And equally, I want you to understand that the rules that relate to this are all set out in Spencer's case, of course. Now, equally, when you look at the relationship with a new purchaser, as it relates to, say, the original tenant, the burden of the covenant will pass as it relates to the parties, and the benefit will pass as well. And this is based on sections 141 and sections 142 of the Law of Property Act. Now, section 79 of the Law of Property Act allows the tenant to enforce covenants against the landlord for breaches caused by the landlord or whoever he sells the reversion to in that regard. So The best situation here, most times, of course, is for there to be, as I keep saying, series of indemnities which pass from one party to the other, so that all in all, the parties are not in a situation where they then get lumped, if you like, with burdens, or indeed are liable to other parties for breaches that they themselves did not commit. Now, everything we've looked at to date is what will have occurred prior to the 1st of January 1996. Well, what happened after 1996? Well, the short point is that based on a Law Commission report in 1988 entitled Landlord and Tenant Privity of Contract and Estate, based on that, we had the new Landlord-Tenant Covenants Act 1995, which took effect on the 1st of January 1996. And pretty much everything that we've looked at before has basically washed away, because remember that this whole consideration as to the landlord and the tenant, and the tenant still being liable, original tenant rather still being liable, original landlord still being liable, all had to do with the enduring privity of contract. Now, under the new Landlord Tenants Covenant Act, of course, we do not have that enduring privity of contracts. We see that the rules have changed because it makes sense. The fact of the matter is that if it is that the landlord has consented that the tenant assign his interest, why should it be that the tenant is still liable? And make no mistake, that's pretty much all that we've been discussing, is that the tenant has had the consent from the landlord in order to assign the remainder of his tenancy, but that is irrelevant because he was an original covenantor. Now, though, the law is looking at it from the standpoint of, wait a minute, if T has asked L, can I assign the remainder of my lease, and L agrees, why should it be that T is still liable on the covenants? And that makes sense. So, when we look at the Landlord-Tenant Covenants Act 1995, it reforms the rules of Privity of Estate and the continuing contractual liability. It does not apply to all leases, though, only those legal and equitable leases created after the 1st of January 1996. So, for example, the new rules do not apply to tenancies created after the 1st of January 1996, but which arose from an earlier agreement. It will certainly not take those into consideration. Well, what are the effects of the new act? Well, there are certain sections which are pretty important, and they tend to be Section 3, Section 5, Section 17, Section 19, Section 21. I will look at some of the main sections, for example. So when we look at Section 5 abolishes the liability of the tenant for rent and other leasehold covenants once the premises have been assigned. So it pretty much gets rid of the enduring privity of contract. That said, however, the parties could, based on Section 17, put in place an authorized guarantee agreement, an AGA. What does that mean? The AGA simply means that, let's say that T wishes to assign to A, but L does not necessarily like A because he's heard not so great things about A. Well, let's say T says, no, he really is a good payer of his bills, for argument's sake. And he says, I can guarantee you he will pay his rent. Well, the landlord will say, fine, I'll take him. But you have to put in place an agreement which says, if he doesn't pay his rent, then you will pick up the slack, meaning you will pay his rent for him. Okay, fine. Then you get an AGA. It would mean, therefore, that the contractual liabilities would still be on T as well as A, but it is only in that scenario under the new act because it is only where there's an AGA in place. Of course, there is also a slight change from the previous position, because in the previous law or under the common law, what would happen is that where, for example, A did not pay the rent, L could wait for an extraordinarily long time before telling T. So T could find himself with, for example, 5 years worth of arrears. Under the new act, there is a limitation on the time that we see the landlord needs to let the original tenant know that the assignee has not been paying the rent. Now, what about when the landlord assigns the reversion? Well, the 95 Act not only abolishes the Privity of Contract rule regarding continuous liability throughout the term of the lease for the original tenant, it also does so for the landlord as well. And when you look at Section 7 and Section 8 of the 95 Act, that now renders Section 141 and 142 of the LPA that we mentioned earlier, which allows the landlord to take the benefit, those also are obsolete. The rule in Spencer's case under the new law becomes obsolete. If we consider also Section 2 and the effect on the tenant, again, it abolishes the distinction between covenants which touch and concern the land and personal covenants. It says any covenant entered into by the tenant and written into the lease will be enforceable by and against the current landlord, by and against the current tenant. But it does say except for personal covenants. Now, the position as it relates to personal covenants is the same under the new act as it was under the common law. Only original L and original T are liable on those covenants. Again, Section 3 looks to remove the enduring privity of contract. So between Section 3 and Section 5, they've done a pretty good job in ensuring that the current parties in the relationship are the parties liable on the covenant and no one else. As I say, there are certain sections which I would urge you to look at. So for example, Section 16, Section 17, 18, 20, 21. A lot of this looks at the authorized guarantee agreement and also how the relationship between landlord and tenant is now enforced. There have been a couple of recent cases which for the most part have looked at how landlords have tried to evade the new act. There is, of course, within the act itself, provisions that the parties are obliged under the act to ensure that their agreement is in line with the act. But that said, as I say, there have been a couple of fairly recent cases which have looked at this. So regardless of whether you're looking at the old position under the common law or whether you're looking at the new position under the 95 Act, I want us now to turn to remedies for a breach of a covenant. Well, if the tenant breaches a covenant, whether that be expressed or implied, there are 5 potential remedies which are available, and they are, of course, distress, damages, an action for arrears, specific performance, and forfeiture. Now, if we consider each in turn, what distress allows the landlord to do is to seize and sell goods on the leased property in order to recover the rent. In fact, one of the things you'll find is that when we come to forfeiture, which allows the landlord to come in and take back the property, you will not be able to engage the remedy of forfeiture unless you have at least gone down the route of distress. But of course, you may seek to levy a distress warrant, but what if the person does not have any goods in his house of any value? or let's assume that you've already gone that route and you're the one as the landlord who sold everything in his property to have settled previous rent arrears, for example. Now, some jurisdictions, certainly Jamaica, for example, does not allow distress anymore as a remedy in this regard, but it is still a remedy which is available to the English landlord. He's not, of course, allowed to force entry because, again, he may fall foul of not only civil but criminal sanctions. There are some items which are privileged items that you cannot take, and you certainly have to make sure that the goods you're taking, in fact, belong to the tenant. You may also get damages. This is, after all, a contract. So, of course, you could sue for damages and ensure that you get your rent from the tenant. But he doesn't have any money to pay the rent. Where is he going to get the money from to pay you in an action? Now, you could also bring an action for arrears of the rent as an option. But again, as I say, that may be difficult given his impecuniosity or current inability to be able to pay. Fourthly, there's specific performance, and it is clear that the tenant may obtain specific performance of the landlord's obligations to repair the premises, and that is one that is open to both, for example, the landlord and the tenant. But for the most part, we see that the types of remedies that are there tend to be remedies that are from the landlord's point of view, because it's generally where the property is not being maintained and so on. But specific performance, given that this is land law, will always, of course, be available. Finally, we'll spend the next few minutes considering forfeiture. Now, forfeiture is the formal way to bring a lease to an end, and it is the main and most common way that will bring a lease to a conclusion. Now, there are certain strict requirements when it comes to forfeiture. Now, the landlord's right to forfeiture depends on whether the tenant has breached a covenant or a condition, because, of course, it will be that there are different approaches depending on what has been broken. Now, the point with forfeiture is that it does require that if you're looking at the tenant's obligations being breached, then the lease may be forfeited even if there is no express forfeiture clause, if you're looking at a condition. Now, if you're looking at a condition, if it is a covenant, there must be an express forfeiture clause in order to forfeit the lease. Now, what happens if, for example, there is a breach for which the landlord can forfeit the lease? By the way, forfeiture is also known as the right of re-entry. The words are used interchangeably. But forfeiture is such a draconian remedy that the law tries to put in place various things to assist the tenant before you get to that point. In fact, as it relates to forfeiture, even after the lease has been forfeited and even after the tenant has left, the tenant may seek what is called relief from forfeiture and be asked to be put back into occupation. Now, a landlord may waive a breach. If he waives the breach, he cannot then seek to forfeit. So let's say, for example, the tenant was not supposed to, for example, assign or sublet, but the tenant assigns or sublets and he accepts the rent. Well, then he cannot use that as the basis to forfeit. Case, of course, is Central Estates and Woolgar. Now, a landlord, in respect of forfeiture, must ensure that, again, he does not fall foul of the criminal law. Because, again, forfeiture does not mean that you can go in and take back your property without any regard for the tenant or his property on premises. Now, as it relates to forfeiture, there are two methods of forfeiture. One, of course, as it relates to non-payment of rent, and the other as it relates to breaches other than non-payment of rent. And the idea is that if you're looking at breaches for non-payment of rent, there are procedures and processes to follow. There must be a set amount of rent that is owed. And as it relates to other than non-payment breaches, then it must be that you give the tenant a chance to remedy it if it is remediable. That is going to take us to the end of today's session. And certainly, if you are signed up to our premium service, then certainly we will, and you are considering this as a topic, then we will, of course, be quite happy to give you the further notes in this regard. But more or less for this session, we have covered everything that is necessary as it relates to forfeiture and as it relates to leasehold covenants.